What you know, alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Thursday, December 11th. I thought we would be eyeball deep in the defense case in the Brian Walsh trial, but they rested without calling any witnesses, which is different from what his defense attorney said during openings, which was Brian was going to take the stand. They said after hearing two key witnesses yesterday, they decided not to. I would venture a guess it would have been Jim, who spent New Year's Eve with them, as well as Anna's friend Alyssa from DC. Very powerful testimony, very credible, and really gave a lot of insight into who Anna was. Not sure you can come back from that. So tomorrow we'll have closings and I think a very quick verdict, but we'll see. I'll be live streaming starting at 9 a.m. for closings, so come hang out with us. We're going to go through a couple of motions in the Kouri Richins case. I received about 10 different documents this week, and I've been wanting to kind of chip away at these. I do not think these have been ruled on yet, but I will keep an eye out for any rulings. The first is the state's motion to pre-admit defendants' interview statements and email. The first section, relief requested and grounds. The state of Utah requests the court pre-admit the defendant's statements provided to detectives during an interview on April 14th, 2023, and an April 17th, 2023 follow-up email to detectives. The statements and email are admissible because they're authentic, not hearsay, relevant. Their probative value is not substantially outweighed by unfair prejudice, and they are complete. The statement of relevant facts. Number one, detectives interviewed the defendant at her residence on April 14th, 2023. That interview was contemporaneously recorded and subsequently transcribed. Number two, the interview contains 6 distinct statements. Number one, Eric Richins' health history. 2, the night of Eric's death. 3, phone deletions. 4, the Eric Richins Living Trust. 5, life insurance. And 6, power of attorney. The defendant's statements from that interview, the state is requesting to pre-admit are, and they list, the exhibit numbers. The state is not seeking to admit portions of the interview redacted in yellow. Number 3, on April 17th, 2023, the defendant sent detectives an email following up on the interview. The state is requesting to admit that entire email. The argument. The defendant's statements are authentic. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. The defendant's interview statements are authentic because she personally made the statements. They were contemporaneously recorded, and there is no evidence of tampering with the recording. The follow-up email is authentic because response to the interview from the defendant's viewpoint was sent from the defendant's email account, and there is no evidence of tampering with the email. The defendant's statements are not hearsay. When the defendant is the declarant, the statements are of a party opponent, which definitionally is not hearsay. When the declarant is someone other than the defendant, the state is not offering the statements for the truth of the matter asserted, but rather offering them for the effect on the hearer. The defendant's statements are relevant. Relevance is a low bar, and they cite State versus Thornton. Evidence is relevant if it has any tendency to make a fact more or less probable that it would be without the evidence, and the fact is of consequence in determining the action. The defendant's interview and email statements contain certain details regarding the defendant's means, motive, and opportunity to cause Eric Richins' death. These details, especially when compared with other evidence in the case, tend to make it more probable that the defendant poisoned Eric Richins. Accordingly, the defendant's statements are relevant. The probative value of the defendant's statements is not substantially outweighed by the danger of any unfair prejudice. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Evidence is not unfairly prejudicial just because it helps the state's case and hurts the accused. The defendant's interview and email statements contain her matter-of-fact narrative, discussion, and opinion regarding details probative to the defendant's means, motive, and opportunity to cause Eric Richins' death. They are not inflammatory, shocking, or misleading, except to the extent the defendant is deliberately misleading detectives to cover up her involvement in Eric Richins' death. Well, that's a burn. Balancing the highly probative value of this evidence against substantial danger of any unfair prejudice weighs heavily in favor of admission. The defendant's statements are complete. If a party introduces all or part of a statement, an adverse party may require the introduction at that time of any other part or any other statement that in fairness ought to be considered at the same time. Utah Rules of Evidence 106 does not require the court to admit the entirety of a recording or writing, but only those portions that are necessary to clarify, explain, or place into context the admitted testimony. They cite a case, State versus Jones. The intent behind Rule 406 is to prevent a misleading impression, not to simply correct a specific misleading instance. A court need only introduce these portions that, in its discretion, are necessary to qualify, explain, or place into context the portion already introduced. The defendant's statements from the redacted interview and email that the state seeks to admit do not create a misleading impression. The remainder of the interview and the email is not necessary in fairness to clarify, qualify, explain, or put into context the statements. Accordingly, the defendant's statements are complete. For the conclusion, the court should pre-admit for the trial the redacted recording and redacted transcript of the defendant's statements to detectives on April 14th, 2023, and an April 17th, 2023 follow-up email because they are authentic, not hearsay, relevant, their probative value is not substantially outweighed by unfair prejudice, and they are complete. This was filed November 26th. I wonder if after that interview, she felt really confident that she was off their radar, that she sent the email to look even more helpful when it really probably bit her in the booty. The next filing, the state's motion to determine admissibility of defendants' jail calls and text messages. The relief requested and grounds. The state of Utah requests the court determine the admissibility for trial of the defendant's statements in certain jail calls and text messages. The statements are admissible because they're authentic, not hearsay, relevant. Their probative value is not substantially outweighed by unfair prejudice, and they are complete. Statement of relevant facts. Number 1, the defendant has placed numerous calls and sent numerous text messages from jail using her unique HomeWave account. Those calls were contemporaneously recorded and subsequently transcribed. Number 2, the defendant's statement from those calls and texts that the state is requesting to admit are listed below and provided to the court on a thumb drive and to defense counsel in box. The state is not seeking to admit the portions of the call and text redacted in yellow. So they have these listed here as exhibits, and it looks like there are 16 separate exhibits. Number 3, the defendant's jail calls and text messages contain certain details regarding her procurement of pain pills from Carmen Lauber, her knowledge about what happened after she went to bed on March 3rd, 2022, the toxicology of Eric Richins' body, Valentine's Day 2022, which, remember, the prosecution theory is on that day, she put something in the sandwich she got for him and left in his work truck. Eric Richins' attitude about suicide, the witness Hayden Jeffs, her consultation with a divorce attorney in 2021, and the transfer to herself and mortgage of her mother's home. Argument: the defendant's statements are authentic. To satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. The defendant's jail calls and text messages are authentic because they present her first-person viewpoint, contain information unique to her, originate from her HomeWave account, and there is no evidence of tampering with the recordings or texts. The next section, the defendant's statements are not hearsay. When the defendant is the declarant, the statements are of a party opponent, which definitionally is not hearsay. That is a hard word to say for me. Definitionally. When the declarant is someone other than the defendant, the state is not offering the statements for the truth of the matter asserted, but rather offering them for the effect on the hearer. The defendant's statements are relevant. The defendant's jail calls and text messages contain certain details regarding the defendant's means, motive, and opportunity to cause Eric Richins' death. These details, especially when compared to other evidence in the case, tend to make it more probable that the defendant poisoned Eric Richins. Accordingly, the defendant's statements are relevant. D. The probative value of the defendant's statement is not substantially outweighed by the danger of unfair prejudice. The defendant's jail calls and text messages contain her matter-of-fact narrative, discussion, and opinion regarding details probative to the defendant's means, motive, and opportunity to cause Eric Richins' death. They're not inflammatory, shocking, or misleading, except to the extent the defendant is deliberately misleading to cover up her involvement in Eric Richins' death. They say that balancing the probative value versus any danger of unfair prejudice weighs heavily in favor of admission. The statements are complete. The defendant's redacted jail calls and text messages do not create misleading impressions. The remainder of the calls and text message strings is not in fairness necessary to qualify, clarify, explain, or contextualize the statements. Accordingly, the redacted jail calls and text messages are complete. Conclusion: the court should find the redacted jail call recordings, redacted transcripts, and redacted text messages are admissible for trial because they are authentic, not hearsay, relevant, their probative value is not substantially outweighed by unfair prejudice, and they are complete. That was also filed on November 26th. Very interesting. So, one thing I've always heard is a lot of times when you've been in jail for a while, you get a little too comfortable and you start letting things slip on your jail calls or your emails or your FaceTimes. And it seems like here to the tune of 16 separate exhibits. I still have a couple of more documents to read through, and we'll get to those at some point. This is going to be a very interesting trial. I don't think we know the half of what they have on her. So very interested to see this one unfold, and it won't be long because it starts in February. All right, that's it for this episode. Hope you guys have a good rest of your afternoon, and we will see you soon.